snooze fest right now. I have nothing to talk about, sadly.
Okay, well, now we're going to record Wal-Mart Stores, Inc. versus Dukes, heard at the Supreme Court of the United States in 2011. Justice Scalia delivered the opinion of the court in which Roberts and Kennedy, Thomas, and Alito joined, and in which Ginsburg, Breyer, Sotomayor, and Kagan joined as to parts 1 and 3. We are presented with one of the most expansive class actions ever. The district court and the Court of Appeals approved the certification. So the cert was approved by both the district court and the appeal court, but reversed by the Supreme Court. Comprising of about 1.5 million plaintiffs, current and former female employees of petitioner Wal-Mart, who allege that the discretion exercised by their local supervisors over pay and promotions matters violates Title VII by discriminating against women. In addition to injunctive and declaratory relief, the plaintiffs seek an award of back pay. We consider whether the certification of the plaintiff class was consistent with the Federal Rules of Civil Procedure 23A and B2. Petitioner Wal-Mart is the nation's largest private employer. In all, Wal-Mart operates approximately 3,400 stores and employs more than 1 million people. Pay and promotion decisions at Wal-Mart are generally committed to local managers' broad discretion, which is exercised in a largely subjective manner. Local store managers may increase the wages of hourly employees within limits, with only limited corporate oversight. As for salaried employees, such as store managers and their deputies, higher corporate authorities have discretion to set their pay within pre-established ranges. Promotions work in a similar fashion. Wal-Mart permits store managers to apply their own subjective criteria when selecting candidates as support managers, which is the first step on the path to management. Managers' broad discretion for both issues. Admission to Wal-Mart's management training program, however, does require that a candidate meet certain objective criteria, including an above-average performance rating, at least 1 year's tenure in the applicant's current position, and a willingness to relocate. But except for those requirements, regional and district managers have discretion to use their own judgment when selecting candidates for management training. Promotion to higher office, for example, assistant manager, co-manager, or store manager, is similarly at the discretion of the employee's superiors after prescribed objective factors are satisfied. The named plaintiffs in the lawsuit, representing 1.5 million members of the certified class, are 3 current and former Wal-Mart employees who allege that the company discriminated against them on the basis of their sex by denying them equal pay or promotions in violation of Title VII of the Civil Rights Act of 1964, as amended, giving a citation. Betty Dukes began working at a Pittsburgh, California Wal-Mart in 1994. She started as a cashier, but later sought and received a promotion to customer service manager. After a series of disciplinary violations, however, Dukes was demoted back to a cashier and then to greeter. Dukes concedes she violated company policy, but contends that the disciplinary actions were, in fact, retaliation for invoking internal complaint procedures and that male employees have not been disciplined for similar infractions. Dukes also claims 2 male greeters in the Pittsburgh store are paid more than she is. Christine Kwapnowski has worked at Sam's Club stores in Missouri and California for most of her adult life. She has held a number of positions, including a supervisory position. She claims that a male manager yelled at her frequently and screamed at female employees, but not at men. The manager in question told her to doll up and wear some makeup and dress a little better. I know. So this is one member or representative member. And so there's 2 representative member of the class. This is the second. The final named plaintiff, Edith Arana, worked at a Walmart store in Duarte, California from 1995 to 2001. In 2000, she approached the store manager on more than one occasion about management training, but was brushed off. Arana concluded she was being denied opportunity for advancement because of her sex. She initiated internal complaint procedures, whereupon she was told to apply directly to the district manager if she thought her store manager was being unfair. Arana, however, decided against that and never applied for management training again. In 2001, she was fired for failure to comply with Walmart's timekeeping policy. These plaintiffs' respondents here do not allege that Walmart has any express corporate policy against the advancement of women. Rather, they claim that their local manager's discretion over pay and promotions is exercised disproportionately in favor of men, leading to unlawful, disparate impact on female employees. And respondents say, because Walmart is aware of this effect, its refusal to cabin its manager's authority amounts to disparate treatment. Their complaint seeks injunctive and declaratory relief, punitive damages, and back pay. It does not ask for compensatory damages, which is a material fact relevant to one of the later elements. Walmart is aware, which rises to disparate treatment for failure to curb their manager's discretion. Important for our purposes, respondents claim that the discrimination to which they have been subjected is common to all Walmart female employees. The basic theory of their case is that a strong and uniform corporate culture permits bias against women to infect, perhaps subconsciously, the discretionary decision-making of each one of Walmart's thousands of managers, thereby making every woman at the company a victim of one common discriminatory practice. Respondents therefore wish to litigate the Title VII claims of all female employees at Walmart stores in a nationwide class action. Class certification is governed by the Federal Rule of Civil Procedure 23. Invoking this provision, respondents move the district court to certify a plaintiff class consisting of all women employed at Walmart domestic retail store at any time since December 26, 1998 who have been or may be subjected to Walmart challenge pay and management track promotion policies and practices. As evidence that there were indeed questions of law or common fact to all the women of Walmart, as Rule 23A2 requires, respondents relied chiefly on three forms of proof. So that is Rule 23A2 requires questions of law or fact common to. So this is element number 2. And the way that they sought to meet that forms of proof was statistical evidence about pay and promotion disparities between men and women, anecdotal reports of discrimination from 120 of Walmart's female employees, and the testimony of a sociologist who conducted a social framework analysis of Walmart's culture and personnel practices and concluded the company was vulnerable to gender discrimination. The class action is an exception to the usual rule that litigation is conducted by and on behalf of the individual named parties only. In order to justify a departure from that rule, a class representative must be part of the class and possess the same interest and suffer the same injury as the class members. And I think this could be element 1. Rule 23A ensures that the named plaintiffs are appropriate representatives of the class whose claims they wish to litigate. The rules for requirements, numerosity, commonality, typicality, and adequate representation effectively limit the class claims to those fairly encompassed by the named plaintiff's claims. The crux of this case is commonality, the rule requiring a plaintiff to show there are questions of law or fact common to the class. So this is the biggest issue. The language is easy to misread since any competently crafted class complaint literally raises common questions. For example, do all of us plaintiffs indeed work for Wal-Mart? Do our managers have discretion over pay? Is that an unlawful employment practice? What remedies should we get? Reciting these questions is not sufficient to obtain class certification. Commonality requires the plaintiff to demonstrate that the class members have suffered the same injury. From General Telephone Company of Southwest versus Falcon. So this is element 2, as we discussed above, but it's more about how that element should be interpreted. From precedent case, maybe precedent, not sure. This does not mean merely that they have all suffered a violation of the same provision of law. Title VII, for example, can be violated in many ways by intentional discrimination or by hiring and promotion criteria that result in disparate impact and by the use of these practices on the part of many different superiors in a single company. Quite obviously, the mere claim of employees of the same company that they suffered a Title VII injury or even a disparate impact Title VII injury gives no cause to believe that their claims can productively be litigated all at once. Their claims must depend upon a common contention. For example, the assertion of discriminatory bias on the part of the same supervisor. That common contention, moreover, must be of such a nature that it is capable of class-wide resolution, which means that determination of its truth or falsity will resolve an issue that is central to the validity of each one of the claims in one stroke. So that's that's cited from another case. What matters to class certification, this is the rest of a citation from the Nagarita case. I feel like this
Margarita.
I think this is from a different case, not Nagarita. The case was Rosario. What matters to class certification is not the raising of common questions, even in droves, but rather the capacity of a class-wide proceeding to generate common answers apt to drive the resolution of the litigation. Dissimilarities within the proposed class are what have the potential to impede the generation of common answers. Rule 23 does not set a mere pleading standard. A party seeking class certification must affirmatively demonstrate his compliance with the rule. That is, he must be prepared to prove that there is, in fact, sufficiently numerous parties, common questions of law or fact, etc. We recognize in Falcon that sometimes it may be necessary for the court to probe behind the pleadings before coming to rest on the certification question, and the certification is proper only if the trial court is satisfied after rigorous analysis and the prerequisites of 23A have been satisfied. So this is like the standard of review for like an appeal case, I think. Frequently, the rigorous analysis will entail some overlap with the merits of the plaintiff's underlying claim that cannot be helped. The class determination generally involves considerations that are enmeshed in the factual and legal issues comprising the plaintiff's cause of action. From Falcon. Nor is there anything unusual about that consequence. The necessity of touching aspects of the nature in order to resolve preliminary matters, jurisdiction and venue is a familiar feature of litigation. In this case, proof of commonality necessarily overlaps with respondent's merits contention that Wal-Mart engages in a pattern or practice of discrimination. That is so because in resolving individuals' Title VII claim, the crux of the inquiry is the reason for the particular employment decision. Here, respondents wish to sue about literally millions of employment decisions at once. Without some glue holding the alleged reasons for all those decisions together, it will be impossible to say that examination of all the class members' claims for relief will produce a common answer to the crucial question why I was disfavored.
Mic check.
Are
we still live?
Yes, they're still alive. But that really is why this was turned over by SCOTUS. We're going to go through 1, 2, 3 more. Well, we're going to go through B and C of part 1, which most of the justices concurred. And then we're going to go to part, oh, that was part 2. I'm sorry. Part 3 is where most of the justices concurred. Part 1, most of them concurred. But on that sentence that I just read, that's part of part 2. So they all concurred with, like, the cause of action, which was part 1. Part 2 is when they're talking about how this element, Rule 23A2, is a serious issue. And why is because the crux of the inquiry, because they're looking, there are questions of law or common fact, there are questions of law or common, oh my God. Rule 23A2, which is commonality, known as commonality, wants the plaintiff to show that there are questions of law or fact common to the class in order to certify a class action. But they're going to case decisions to define what questions of law and fact common to the class are. And one, it requires that they have suffered the same injury. So that's one elaboration on that element. The second is that the claims must depend upon a common contention, which they're not finding because they further drive into what's a common contention. And what they're saying is that that means the determination of its truth or falsity will resolve an issue that is central to the validity of each one of the claims in one stroke in order to qualify as a class. But they're saying that if you made this a class with the central question of law and fact that's common to all of them is is a disfavorable employment decision. 1.5 million different disfavorable employment decisions could not be answered in one court decision because they're saying the inquiry is the reason, the crux of the inquiry is the reason for the particular employment decision. And without some glue holding the alleged reasons for all of those decisions together, it will be impossible to say that examination of all the class members' claims for relief will produce a common answer to the crucial question of why I was disfavored. Because each person was disfavored for different reasons. So they don't actually have a question of law or fact that is common to all individuals. So Part B of Part 2, and this one is the one that a couple of the justices disagree with, is this court's opinion. Falcon describes how the commonality issue must be approached. There, an employee who claimed that he was deliberately denied a promotion on account of race obtained certification of a class comprising all employees wrongfully denied promotions and all applicants wrongfully denied jobs. We rejected that composite class for lack of commonality and typicality, explaining. Conceptually, there is a wide gap between A, an individual's claim that he was denied a promotion or higher pay on discriminatory grounds, and his otherwise unsupported allegation that the company has a policy of discrimination, and B, the existence of a class of persons who have suffered the same injury as that individual, such that the individual's claim and the class claim will share common questions of law or fact, and that the individual's claim will be typical of the class claims. Falcon suggested two ways in which the conceptual gap might be bridged. First, if the employer used a biased testing procedure to evaluate both applicants for employment and incumbent employees, a class action on behalf of every applicant or employee who might have been prejudiced by the test clearly would satisfy the commonality and typicality requirements of Rule 23A. Second, significant proof that an employer operated under a general policy of discrimination conceivably could justify a class of both applicants and employees if the discrimination manifested itself in hiring and promotion practices in the same general fashion, such as through entirely subjective decision-making processes. We think the statement precisely describes respondents' burden in this case. The first manner of bridging the gap obviously has no application here. Wal-Mart has no testing procedure or other company-wide evaluation method that can be charged with bias. The whole point of permitting discretionary decision-making is to avoid evaluating employees under a common standard. Second manner of bridging the gap requires significant proof that Wal-Mart operated under a general policy of discrimination. That is entirely absent here. Wal-Mart announced policy forbids sex discrimination, and as the district court recognized, the company imposes penalties for denials of equal employment. So this is a material fact that was found at the district court, so it's indisputed that there was a policy against sex discrimination that had penalties. The only evidence of a general policy of discrimination respondents produced was the testimony of Dr. William Bealby, their sociological expert, relying on social framework analysis. Bealby testified that Wal-Mart has a strong corporate culture that makes it vulnerable to gender bias. He could not, however, determine with any specificity how regularly stereotypes play a meaningful role in employment decisions at Wal-Mart. At his deposition, Dr. Bealby conceded that he could not calculate whether 0.5% or 95% of the employment decisions at Wal-Mart might be determined by stereotype thinking. Bealby's testimony does nothing to advance respondent's case. Whether 0.5% or 95% of the employment decision at Wal-Mart might be determined by stereotype thinking is the essential question on which respondent's theory of commonality depends. If Bealby admittedly has no answer to that question, we can safely disregard what he has to say. It is worlds away from significant proof that Wal-Mart operated under a general policy of discrimination. So the expert witness basically harmed their case, the issue at the crux of the case. So, the only corporate policy that the plaintiff's evidence convincingly establishes is Wal-Mart's policy of allowing discretion by local supervisors over employment matters. On its face, of course, that is just the opposite of a uniform employment practice that would provide the commonality needed for a class action. It is a policy against having uniform employment practices. It is also a very common and presumptively reasonable way of doing business, one that we have said should itself raise no inference of discriminatory conduct. To be sure, we have recognized that in appropriate cases, giving discretion to lower level supervisors can be the basis of Title VII liability under disparate impact theory, since an employer's undisciplined system of subjective decision making can have precisely the same effects of a system pervading by impermissible intentional discrimination. But the recognition of this type of Title VII claim can exist does not lead to the conclusion that every employee in a company using a system of discretion has such a claim in common. To the contrary, left to their own devices, most managers in any corporation, and surely most managers in a corporation that forbids sex discrimination, would select sex-neutral, performance-based criteria for hiring and promotion that produce no actionable disparity at all. Others may choose to reward various attributes that produce disparate impacts, such as scores on general aptitude tests or educational achievements. And still, other managers may be guilty of intentional discrimination that produces sex-based disparity. In such a company, demonstrating the invalidity of one manager's use of discretion will do nothing to demonstrate the invalidity of another's. A party seeking to certify a nationwide class will be unable to show that all the employees' Title VII claims will in fact depend on the answers to common questions. Respondents have not identified a common mode of exercising discretion that pervades the entire company, aside from their reliance on Dr. Bealby's social frameworks analysis that we have rejected. In a company of Wal-Mart's size and geographical scope, it is quite unbelievable that all managers would exercise their discretion in a common way without some common direction. Respondents attempt to make a showing by means of statistical and anecdotal evidence, but their evidence falls well short. The statistical evidence consists primarily of regression analysis performed by Dr. Richard Drogan, a statistician, and Dr. Mark Bendick, a labor economist. Drogan conducted his analysis region by region, comparing the number of women promoted into management positions with the percentage of women in the available pool of hourly workers. After considering regional and national data, Drogan concluded that there are statistically significant disparities between men and women at Wal-Mart, and these disparities can be explained only by gender discrimination. Bendick compared workforce data from Wal-Mart and competitive retailers and concluded that Wal-Mart promotes a lower percentage of women than its competitors. Even if they are taken at face value, these studies are insufficient to establish the respondent's theory can be proved on a class-wide basis. In Falcon, we held that one named plaintiff experience of discrimination was insufficient to infer that discriminatory treatment is typical of the employer's employment practice. A similar failure of inference arises here. Information about disparities at the regional and national level does not establish the existence of disparities at individual stores, let alone raise the inference that a company-wide policy of discrimination is implemented by discretionary decisions at the store and district level. A regional pay disparity, for example, may be attributable to only a small set of Walmart stores and cannot be itself establish the uniform store-by-store disparity upon which the plaintiff's theory of commonality depends. There is another more fundamental respect in which respondent's statistical proof fails, even if it established, as it does not, a pay or promotion pattern that differ from the nationwide figures or the regional figures in all of Walmart's 3,400 stores, that would still not demonstrate the commonality of issue exists. Some managers will claim that the availability of women or qualified women or interested women in their store areas does not mirror the national and regional statistics, and almost all of them will claim to have been applying some sex-neutral, performance-based criteria whose nature and effects will differ from store to store. In the landmark case of ours, which held that giving discretion to lower-level supervisors can be the basis of Title VII liability under disparate impact theory, the plurality opinion conditions. Okay, so it looks like a preceding case only arose to a plural opinion, which means that the justices were torn in half, and it has no presidential effect. But the plurality opinion condition that holding on the corollary that merely providing the discretionary system has produced a racial or sexual disparity is not enough. The plaintiff must begin by identifying the specific employment practice that is challenged. And the Watson case accords to the Ward's case, approving that statement, superseded by statute on other grounds, citing the statute. That is all the more necessary when a class of plaintiffs is sought to be certified. Other than the bare existence of delegated discretion, respondents have identified no specific employment practice, much less one that ties their 1.5 million claims together. Merely showing that Wal-Mart's policy of discretion has produced an overall sex-based disparity does not suffice. Respondents' anecdotal evidence. So they're kind of just going evidence by evidence. So this was their statistical evidence, facts about the statistical evidence. Now we're going to facts about the anecdotal evidence. Suffers from the same defects, and in addition is too weak to raise an inference that all the individual discretionary personnel decisions are discriminatory. Here, respondents filed some 120 affidavits reporting experiences of discrimination, about one for every 12,500 class members, relating to only some 235 out of Wal-Mart's 3,400 stores. More than half of these reports are concentrated in only 6 states: Alabama, California, Florida, Missouri, Texas, and Wisconsin. Half of all states have only 1 or 2 anecdotes, and 14 states have no anecdotes about Wal-Mart's operations at all. Even if every single one of these accounts is true, that would not demonstrate that the entire company operates under a general policy of discrimination, according to Falcon, which is what respondents must show to certify a company-wide class. Look at who came out. Say hi. Rule 23b2 allows class treatment when the party opposing class has acted or refused to act on the grounds that apply generally to the class, so that final injunctive relief or corresponding declaratory relief is appropriate, respecting the class as a whole. He left.
He likes listening to.
Class as a whole. Where was I? Okay. One possible reading of this provision is that it applies only to requests for such injunctive or declaratory relief and does not authorize the class certification of monetary claims at all. We do not reach that broader question in this case because we think that at a minimum, claims for individualized relief, like the back pay at issue here, do not satisfy the rule. The key to the B2 class is the indivisible nature of the injunctive or declaratory remedy warranted. The notion that the conduct is such that it can be enjoined or declared unlawful only as to all of the class members or as to none of them. In other words, Rule 23b2 applies only when a single injunction or declaratory judgment would provide relief to each member of the class. It does not authorize class certification when each individual class member would be entitled to different injunction or declaratory judgment against the defendant. Similarly, it does not authorize class certification when each class member would be entitled to an individualized award of money damages. That interpretation accords with the history of the rule because Rule 23 stems from equity practice that predated its codification. In determining its meaning, we have previously looked at the historical models on which the rule was based. As we observed in Amchem Products Inc. versus Windsor, civil rights cases against parties charged with unlawful class-based discrimination are prime examples of what B2 is meant to capture. In particular, the rule reflects a series of decisions involving challenges to racial segregation, conduct that was remedied by a single class-wide order. In none of the cases cited by the advisory committee as examples of B2's antecedents did the plaintiffs combine any claim for individualized relief with their class-wide injunction. And this is coming from the advisory committee's note, and it cites more cases. But it's basically saying in antecedent cases, none of them that were cited did the plaintiffs combine any claim for individualized relief with their class-wide injunction. So the fact that there is a back pay monetary damages award being prayed for here is something that I think would make it fail B2. At least it would be out of line with all of the cases cited in the advisory committee's note, which is on the topic of equity practice, stems from the definition of the legislative intent is to correct equity practice. So permitting the combination of individualized and class-wide relief in a B2 class is also inconsistent with the structure of Rule 23B. Classes certified under B1 and B2 share the most traditional justifications for class treatment that individual adjudications would be impossible or unworkable as a B1 basis. Right, so it comes in conflict when you're looking for individual, what do they call it? Individualized award of money damages comes into conflict with two elements. And the first one is B1, Rule 23B1. That would be unworkable. Or that the relief sought must perforce affect the entire class at once, as in a B2 class. For that reason, these are also mandatory classes. The rule provides no opportunity for B1 or B2 class members to opt out and does not even oblige the district court to afford them notice of the action. So this is the no notice, no opt out. Basis for class certification, which means that they truly need to have commonality and typicality, and not be impossible or unworkable. By contrast, is an adventuresome innovation of the 1966 amendments, Amchem, framed for situations in which class action treatment is not as clearly called for. It allows class certification in a much wider set of circumstances, but with greater procedural protections. Its only prerequisites are that the questions of law or fact common to class members predominate over any questions affecting only individual members, and that the class action is superior to other available methods for fairly and efficiently adjudicating the controversy. So this is another element of B3 now. is for predominant, meaning that the questions of law or fact common to class members predominate over any questions affecting only individual members, and that a class action is superior to other available methods for fairly and efficiently adjudicating controversy. So there's two different elements. In here, that individualized award of money damages again comes into direct conflict with the predominant prong. So unlike B1 and B2 cases, the B3 class is not mandatory. Class members are entitled to receive the best notice that is practicable under the circumstances and to withdraw from the class at their option. So, given that structure, we think it clear that individualized monetary claims belong in Rule 23b3. The procedural protections attending the B3 class, predominant superiority, mandatory notice, and the right to opt out are missing from B2, not because the rule considers them unnecessary, but because it considers them unnecessary to a B2 class. When a class seeks an indivisible injunction benefiting all of its members at once, when there is no reason to undertake a case-specific inquiry into whether class issues predominate or whether class action is a superior method of adjudicating the dispute. Predominance and superiority are self-evident in the B2 class. But with respect to each class member's individualized claim for money, that is not so, which is precisely why B3 requires a judge to make findings about predominance and superiority before allowing class. Similarly, B2 does not require that class members be given notice and opt-out rights, presumably because it is thought, rightly or wrongly, that notice has no purpose when the class is mandatory and that depriving people of their right to sue in this manner complies with the Due Process Clause. In the context of a class action predominantly for money damages, we have held that absence of notice and opt-out violation violates due process. See Phillips Petroleum Company v. Schutz of 1985. While we have never held that to be so where the monetary claims do not predominate, the serious possibility that it may be so provides an additional reason not to read Rule 23b2 to include the monetary claims here. Against that conclusion, respondents argue that their claims for back pay were appropriately certified as part of the class under Rule 23b2 because those claims were not predominant over the request for injunctive and declaratory relief. They rely upon the advisory committee statement that Rule 23b2 does not extend money damages. Emphasis added. The negative implication, they argue, is that it does extend to cases in which the appropriate final relief relates only partially and non-predominantly to money damages. Of course, it is the rule itself, not the advisory committee's description of it, that governs, and a mere negative inference does not, in our view, what was that? Where was I? Okay, hold on. And a mere negative inference does not, in our view, suffice to establish a disposition that has no basis in the rule's text and does not obvious violence to the rule's structural features. The mere predominance of a proper B2 injunctive claims is nothing to justify the elimination of Rule 23b3's procedural protections. It neither establishes the superiority of a class adjudication over individual adjudication, nor cures the notice and opt-out problems. We fail to see why the rule should be read to nullify these protections, whether a plaintiff class at its option combines its monetary claims with a request, even a predominating request for injunction. Respondents' predominance test, moreover, creates perverse incentives for class representatives to take place to take place.
Whoa.
Where
Close up.
was I? To take place at risk potentially valid claims for monetary relief. In this case, for example, the named plaintiffs declined to include employees' claims for compensatory damage, including damages in their complaint. That strategy of including only back pay claims made it more likely that monetary relief would not predominate. But it also created the possibility, if the predominance tests were correct, that individual class members' compensatory damages claims would be precluded by litigation they had no power to hold themselves apart from. If it were determined, for example, that a particular class member is not entitled to back pay because her denial of increased pay or a promotion was not the product of discrimination, that employee might be collaterally stopped from independently seeking compensatory damages based on that same denial. That possibility underscores the need for plaintiffs with individual monetary claims to decide for themselves whether to tie their fates to the class representatives or go it alone. A choice Rule 23b2 does not ensure that they have. Finally, respondents argue that their back pay claims are appropriate for a B2 class action because the back pay award is equitable in nature. The latter may be true, but it is irrelevant. The rule does not speak of equitable remedies generally, but injunctions and declaratory judgments. As Title VII itself makes pellucidly clear, back pay is neither. See the citation, part Romanet 1 and Romanet 2, distinguishing between declaratory and injunctive relief and the payment of back pay. All right, Part C and Part 3, which is the last paragraph here before we talk about reversing the Court of Appeal decision, is that in Allison v. Citgo Petroleum Corp., the Fifth Circuit held that a B2 class would permit the certification of money relief that is incidental to requested injunctive or declaratory relief, which it defined as damages that flow directly from liability to the class as a whole on the claims forming the basis of the injunctive or declaratory relief. In that court's view, such incidental damage would not require additional hearings to resolve the disparate merits of each individual's case. It should neither introduce new substantial legal or factual issues nor entail complex individualized determinations. So this is yet another case against individualized monetary damage awards. We need not decide in this case whether there are any forms of incidental monetary relief that are consistent with the interpretation of Rule 23b2 we have announced and that comply with the Due Process Clause. Respondents do not argue that they can satisfy the standard. In any event, they cannot. So, some of the justices concurred in part and dissented in part. And they concurred in Part 1 and about the factual makeup, and Part 3 about how this individualized monetary damages award is one of the biggest reasons for the denial of class certification. But they did disagree with Part 2, which seemed to go over the commonality and typicality elements and consider the sociologist, expert witness, statistical evidence, and the anecdotal evidence. And Ginsburg, Breyer, Sotomayor, and Kagan concur, yet dissent in this part. The class in this case, I agree with the court, should not have been certified under the rule. The plaintiffs alleging discrimination in violation of Title VII seek monetary relief that is not merely incidental to any injunctive or declaratory relief that may be available. A putative class of this type may be certifiable under Rule 23b3 if the plaintiffs show that common class questions predominate over issues affecting individuals. For example, qualification for and the amount of back pay or compensatory damages, and that a class action is superior to other modes of adjudication. Whether the class of plaintiffs described meets the specific requirements of Rule 23b3 is not before the court, and I would reserve that matter for consideration and decision on remand. The court, however, disqualifies the class at the starting gate, holding that the plaintiffs cannot cross the commonality line set by Rule 23a2. In so ruling, the court imports into the Rule 23a discrimination concerns properly addressed in a Rule 23b3 assessment. Rule 23a2 establishes a preliminary requirement for maintaining a class action. There are questions of law or fact common to the class. The rule does not require that all questions of law or fact raised in the litigation be common. Indeed, and they're going to something here from some secondary source here. Indeed, quoting, even a single question of law or fact common to the members of the class will satisfy the commonality requirement. And they're going back to Nagarenda. We must have cited that source. The pre-existing principle and the structure of the class action, which is another secondary source. See Advisory Committee's 1937 notes on the Civil Federal Procedure, citing with approval cases in which there was only a question of law or fact common to the class members. A question is ordinarily understood to be a subject or point open to controversy, as defined in the dictionary. In the Black's Law Dictionary, it defines question of fact as a disputed issue to be resolved at trial, and questions of law as an issue to be decided by the judge. Thus, a question common to the class must be a dispute, either of fact or of law, the resolution of which will advance the determination of the class member's claims. The district court's identification of a common question, what they're saying is, with the dissenting opinion is trying, at least dissenting in this part, is trying to say is that to certify for a class, as a class, there need be only one question. Question or law, question of law or fact. And I totally disagree with that. I mean, like reading this rule again, it says, there are questions of law or fact common to the class. I don't know, perhaps only one question of law or one question of fact is required to certify a class. But that's not the only element of Rule 23b2. So there's more to it, like, is one answer going to satisfy their common question? And that would be impossible, rendering the reason to certify the class on that one question is insufficient. So anyway, the district court's identification of a common question, whether Wal-Mart's pay and promotions policies gave rise to unlawful discrimination, was hardly infirm. The practice of delegating to supervisors large discretion to make personnel decisions uncontrolled by formal standards has long been known to have potential to produce disparate impacts. However, as we learn from the facts, there is a complaints process that was evoked by two of the representative members of the class. So that is false. It was not uncontrolled. Managers, like all humankind, may be prey to biases of which they are unaware. The risk of discrimination is heightened when those managers are predominantly of one sex and are steeped in a corporate culture that perpetuates gender stereotypes. We have held that discretionary employment practices can give rise to Title VII claims, not only when such practices are motivated by discriminatory intent, but also when they produce discriminatory results. Citing the Watson case. In Watson, as here, the employer had given its managers large authority over promotions, and employees sued the bank under Title VII, alleging that the discretionary promotion system caused a discriminatory effect based on race. 4 different supervisors had declined on separate occasions to promote the employee. Their reasons were subjective and unknown. The employer, we noted, had not developed precise and formal criteria for evaluating candidates. It relied instead on the subjective judgment of supervisors. Aware of the problem of subconscious stereotypes and prejudices, we held that the employer's undisciplined system of subjective decision-making was an employment practice that may be analyzed under the disparate impact approach. Recognizing the use of subjective decision-making as an employment practice subject to disparate impact attack. So they're trying to legitimize this issue, which may have worked if they were only looking for injunctive relief or declaratory relief, but they were looking for money damages of back pay as equitable relief, which is what destroyed them. But they're trying to make a case that not curtailing management discretion is an employment practice that is subject to class certification under the commonality and commonality, at least, prerequisite. So, the plaintiff's allegations state claims of gender discrimination in the form of biased decision-making in both pay and promotions. The evidence reviewed by the district court adequately demonstrated that resolving those claims would necessitate examination of particular policies and practices alleged to affect adversely and globally women employed at Wal-Mart stores. Setting a necessary but not a sufficient criterion for class action certification demands nothing further. The court gives no credence to the key dispute common to the class, whether Wal-Mart's discretionary pay and promotion policies are discriminatory. What matters, the court asserts, is not the raising of common questions, but whether there are dissimilarities within the proposed class that have the potential to impede the generation of common answers, which I kind of agree to. I don't know why there's a problem with that analysis. The court, you can't say that every single female employee has been discriminated against and deserves a reward. You just can't. In other words, that's the simplest way to put. Not every single one of your 1.5 female employees has been discriminated against. The court blends Rule 23A2 threshold criterion with the more demanding criteria of 23B3 and thereby elevates the 2A inquiry so that it is no longer easily satisfied. It just requires more work on the part of the plaintiff's attorney. Rather than saying 1.5 in every single female employee, they should have said every single female employee that asked for a promotion and was denied and wasn't given reasonable grounds for denial. Anyway, and that's just promotion. That's not even talking about the pay gap. And there's no ability to resolve a pay gap issue. You can't ask for a remedy of 1.5 million different people being paid different rates. There's no one solution that would be able to apply to all 1.5 million women unless you took the amount of the gap and you somehow averaged it out to how that harm experienced by all of them can be remediated in terms of hourly pay based on like their role. And I still think that is just, what do they call that? It's not democratic. That's all I know. They call it wealth distribution. I don't know. So Rule 23B3 certification requires, in addition to the 423A findings, determinations that questions of law or fact common to the class members predominate over any questions affecting only individual members, and that a class action is superior to other available methods for adjudicating the controversy. So where does this come out of? B3? So I don't understand why they have a problem with B3 at all, but this is almost done. The court's emphasis on the differences between class members mimics the Rule 23B3 inquiry into whether common questions predominate over individual issues. And by asking whether the individual differences impede common adjudication, the court duplicates the 23B3's question whether a class action is superior to other modes of adjudication. Indeed, Professor Nagarita, whose dissimilarities inquiry the court endorses, developed his position in the context of Rule 23B3 requires some decisive degree of similarity across the proposed class because it speaks of common questions that predominate over individual ones. The Rule 23B3 predominant inquiry is meant to test whether proposed classes are sufficiently cohesive to warrant adjudication by representation. Amchem Products versus Windsor is the citation for that. If courts must conduct a dissimilarities analysis in 23A2 stage, no omission remains for Rule 23B3. Because 23A is also a prerequisite for 23B1 and 23B2 classes, the court's dissimilarities position is far-reaching. Individual differences should not bar Rule 23B1 or Rule 23B2 class so long as the Rule 23A threshold is met. See Amchem Products. So they're trying to say there's two hoops, and if they get through one hoop, they shouldn't have to go through it again. Or no, there's two rules calling for the same hoop to be jumped through. Relatively the same hoop. I mean, they view it as the same hoop. And if they pass through that hoop, they shouldn't have to go through another hoop that's really close to it to become certified as a class, which I disagree. It's a different hoop, similar elements. Again, trying to root out dissimilar cases and claims. Rule 23B2 action, in which the court noted that it is unlikely that differences in the factual background of each claim will affect the outcome of the legal issue. For example, Franks v. Bowman Transportation Corp. A Rule 23B2 class of African American truck drivers complained that the defendant had discriminatorily refused to hire black applicants. We recognize that the qualifications and performance of individual class members might vary, internal quotation marks omitted. Generalizations concerning such individually applicable evidence, we cautioned, cannot serve as a justification for the denial of injunctive relief to the entire class. The dissimilarities approach leads the court to train its attention on what distinguishes individual class members rather than on what unites them. Given the lack of standards for pay and promotion, the majority says demonstrating the invalidity of one manager's use of discretion will do nothing to demonstrate the invalidity of another's. Walmart's delegation of discretion over pay and promotions is a policy uniform throughout all stores. The very nature of discretion is that people will exercise it in various ways. A system of delegated discretion, Watson held, is a practice actionable under Title VII when it produces discriminatory outcomes. A finding that Walmart's pay and promotions practices in fact violate the law would be the first step in the usual order of proofs for plaintiffs seeking individual remedies for company-wide discrimination. And they're citing two cases, Teamsters versus United States and Albemarle Paper Company versus Moody, that individual employees Unique circumstances will ultimately determine whether she is entitled to back pay or damages. Barring back pay if the plaintiff was refused advancement for any reason other than discrimination should not factor into the Rule 23A2 determination. But it fails nonetheless because you can't resolve an inquiry of $1.5 million back pay issue without looking at each employee separately. The court errs in importing and then it fails to certify. So it's just like a moot point that the other case synthesized, or the majority justice synthesized, and the dissenting opinion wants to look at in isolation on a case that would have failed anyway. The court errs in importing a dissimilarities notion suited to Rule 23b3 into the 23a commonality inquiry. I therefore cannot join Part 2 of the court's opinion. I mean, that's fine. That's fine. It still fails, and they know it.